And welcome everybody to the 25th edition of the Deserve to Win podcast. As always, I'm your host, Eric J. Troutman, the Czar of the TCPA, the Czar of just about everything. Great to have you folks. We have a fantastic guest today, Andrew Perrong, who you've seen before, but never like this because he's dyed his hair to look like he's in a boy band. You're going to love this. But before we get there, who do we have? We'll start with you.
I am Pooja Amin, Queenie of TCPA World and partner at Troutman Amin.
Fantastic to have you. And to your right?
I am Tori Guidry, an associate at Troutman Amin and the Dame of TCPA World.
The powerful blonde dame. Longer hair than ever before. I like it. She's promised to go back to redhead soon, by the way. The clock is ticking. We'll find out. And to my left, who do we have?
Hi guys, my name is Brittany. I am a now partner of Troutman Amin, and I'm also known as the Baroness of TCPA World.
Yeah, you know, you stole a little bit of my thunder. I was going to make that announcement, but I guess it makes sense that you would have to announce that you're the partner. So a lot of milestones. So look, first of all, it's been a little while since we've had a podcast, and I'm so sorry, folks. We've just been, frankly, incredibly busy. But we love all of you so much, and we're going to get back to on pace here and get some more of these podcasts out. I know you guys all love these things. But yeah, so lots of milestones in May. One of the big ones, of course, is Brittany is now our partner here at Troutman Amin, and we could not be happier. Incredibly well-deserved. I wish I could spend the time, but I can't, to talk about how amazing she is and how incredible she came in and just how much growth she's had over the last couple of years and just how capable and talented and dedicated of an attorney you really are to have earned this fantastic thing. You'll definitely give me the youngest partner this firm will ever have. There's no question. Like you are it. You have etched your name in eternity, and it's incredibly well deserved. So really, really excited to have that happen. It's also the 1-year anniversary, of course, of Troutman Amin, of Pooja getting her name on the door, which is fantastic. And we've got lots of other milestones, including, of course, LCOC has been, first of all, it's been called LCOC as opposed to LCOC. It's sold out, which is amazing. Our YouTube channel has more followers than more than half of the world's largest law firms. A tremendous number of video tremendous amount of video engagement. Just hundreds of thousands of views on our website, or excuse me, on our YouTube channel, and of course on our website, which TCPA World's tracking to have over 1 million views this year, just this year alone. It's fantastic. We've just had a huge run of success in May. Could not be happier, and again, it's so splendid, I think, to have Brittany as our partner now. I just love that so much. Unfortunately, though, again, it has been a little while since we've gotten together. That means there's so much to cover. And having Perrong on a second time, it's weird. It's strange that he's our guy that we're going to have twice, but he's making a lot of noise. So we got to talk to him. There's got some big rulings that we got to talk to him about. But there's a ton of big rulings out there. I'm going to go first. I want to talk about this ruling in Drazen versus Pinto, which is a massive ruling from the 11th Circuit Court of Appeal that really may turn TCPA World on its head from a litigation standpoint. Now, this is kind of like a nerdy ruling. Most folks that aren't litigators probably aren't going to grasp everything I'm about to talk about. But in the TCPA world, it's very common that you're going to have a settlement of a TCPA class action, right? We see this all the time. This is why these class actions are brought. The plaintiff's lawyer is hoping to get a big class settlement that might be worth millions of dollars, and where the plaintiff's lawyers will get millions of dollars all in one case, right? That's what they're after. That's the gold mine that they're always looking for. And defendants will sometimes do this because they're facing liability, perhaps, where you've got $500 per call. Let's say you're a big direct-to-consumer marketer. Let's say you're making 1 million calls a day, right? I mean, you might be talking about $500 million in potential exposure a day under the TCPA. Of course, these companies are very sophisticated. They're not just wholesale violating the statute, but there's always going to be some percentage, right, of your calls. If you're making 1 million calls a day, it's impossible. It's just impossible to comply with the statute 100%, right? There's going to be some percentage of those where the phone number changed hands, or a phone number was fat-fingered, or a lead source was invalid, or your system screwed up that day and sent out a segment of calls it shouldn't have sent out. These errors are going to occur. And many times, there'll be some technology gap or some oversight that takes place with a large company, and they'll realize, oh my goodness, there's 100 million calls that just shouldn't have been made, or there's 10 million calls, or even 1 million calls that shouldn't have been made, and they realize they're facing $500 million minimum exposure, maybe billions in exposure, and they think, oh my God, what are we going to do? And in these cases, right, the TCPA marketplace, if you will, for TCPA settlements has been around for 10 years now. It's a highly evolved marketplace with a very specific price depending on the type of case, what you can expect on a per class member basis to settle these cases for on what's called a common fund basis. And in the 11th Circuit, up until this case called Drazen, what's called a rescissionary common fund was the most common way that a TCPA class action would settle. And the way it would work would be that the defendant would agree to some amount of money that they would pay per class member that makes a claim. All right, and this is very important. So you've got, let's say you've got 1 million people in the class, right? And let's say that you're going to settle that for $10 per class member. And again, at $500 per call, $10, not per call, understand, per class member is a fantastic settlement already, right? That's already 1/50th of the exposure potentially. And it could be much more if there was like 10 calls made to each class member. Now you're talking about 1/500th of the exposure you're settling for, right? So, hey, you might be thinking, hey, you know what? A $10 per class, million people, $10 million on $1 billion in exposure, that is a pretty good settlement already. But wait, it gets better. So out of that 10 million, you're not going to actually have to pay $10 to every single person that makes a claim. Instead, there's going to be some payment that's made pro rata to each individual who actually makes a claim. So in some instances, you'll get a situation where maybe only 5% of the class, right, makes that claim. So not 1 million people are going to get $10, but only 5%, 50,000 are going to get $10. So rather than spending $10 million, you're actually only spending $500,000 to settle that class. But here's the rub. That million class members, just because they're in the class, automatically give you a full release as a defendant. And that is exactly what happened in a settlement that GoDaddy had under the TCPA, which was actually in an ATDS case, ironically enough, which was rushed to approval right before the U.S. Supreme Court decided Facebook, which would have wiped out these claims. Now, the 11th Circuit Court of Appeal, in looking at this settlement, was deeply concerned with a number of pieces of the settlement. And this is very important, again, for class action litigators. They were deeply concerned with what they viewed as collusion between GoDaddy's counsel and the plaintiff's lawyers to get GoDaddy the biggest possible release possible in exchange for millions of dollars in settlement fees, or excuse me, in attorney's fees to the plaintiff's lawyers. So to complete how this works, in the $10 million settlement we talked about before, only $500,000 would go to the class in this hypothetical class, right? But the plaintiff's lawyers would take 1/3 of the 10 million. So the plaintiff's lawyers would get paid 3.3 million guaranteed. Again, this is a hypothetical settlement. This is not the GoDaddy settlement. This is a hypothetical but very typical settlement structure. The plaintiff's lawyers would get 3.3 million. The class would get 500,000. This so-called $10 million class is really a $3.8 million class. It'd be $200,000 perhaps for administration costs, so it'll cost $4 million. It's billed as a $10 million class, but $6 million goes back to the hypothetical TCPA defendant, and so they've settled essentially $500 million or more in exposure under the TCPA for $4 million. 3.3 of which goes to the plaintiff's lawyers. And that is how the dirty sausage is made in TCPA world. And that was perfectly legal until this Drazen case. Now the 11th Circuit looked at a very similar structure where ultimately the plaintiff's lawyers were going to get $7 million in what was billed as a $30 million settlement, but really it was like only $1 million was actually going to go to the class. So, and I guess these are rough numbers, don't quote me here. So you're talking about probably $9 million total would have been paid on what was billed as a $30 million class because of the claims-made nature of the settlement. And of that $9 million, $7 million was going to the attorneys, and only $2 million was going to the class. The 11th Circuit Court of Appeal looked at this and said, time out. First of all, the release that's being given is way broader than it should have been. And oh, by the way, less than 2% of the class made a claim. That means, as the 11th Circuit pointed out, 98.1% of this class gave up all of their claims against GoDaddy, even more claims than were actually asserted in the complaint. A broad release, 98% gave away all their rights against GoDaddy in exchange for nothing. They did not get one penny, not one penny. And the plaintiff's lawyers, the class counsel, in the 11th Circuit Court of Appeals perspective, completely missed the boat. They failed, and they colluded with GoDaddy's counsel, who basically took advantage of them in order to get their $7 million that they had been promised. The 11th Circuit found this to be terrible and actually found, just in a stunning, for me, just a stunning ruling, that the class counsel was essentially at odds with the class and they were inadequate to represent the class because of just how inappropriate this structure that they were advocating for ended up being. Unbelievable ruling. Like you rarely see a district court find class counsel to be inadequate. To have an appellate court say as a matter of law that you're inadequate, that is just incredible. But the appellate court didn't stop there. The appellate court also chided the district court and said, district court, like, you are a fiduciary. You are a gatekeeper of the class. You're supposed to protect the class from exactly this sort of thing, this collusion between GoDaddy's lawyers, who, by the way, right, like, they did a good job for their client, even if they did a bad job ethically by allegedly colluding. Look, I don't know that they colluded. I don't know what happened. I wasn't there. All I'm reporting on is what the 11th Circuit Court of Appeal found, and the 11th Circuit Court of Appeal found that the district court ignored evidence of collusion. And that's a big deal. So moving forward, the 11th Circuit Court of Appeal has made it clear that district courts need to heavily test these settlements to see, did the defense lawyers and the plaintiff's lawyers, did they collude? Is the defendant getting more than they should be getting? Is the plaintiff's lawyer getting more money than they should be getting? Is the money that they're seeking out of whack with the actual compensation that's going to be paid to the class? If so, these are big red flags. And the district court, again, needs to operate as a fiduciary, as a protector of that class to make sure that these lawyers, these greedy lawyers that just want their millions of dollars, aren't selling their clients down the river. And in this case, the court found that they did. There's also some really interesting pieces around the content of the notice. For instance, the fact that Facebook was set to determine whether or not an ATDS ruling was available, or ATDS claim was available to the class members. That was never actually disclosed in any of the class notice materials, which the 11th Circuit Court of Appeal was like, that is just a flat violation of due process. And it's pretty hard to argue, right? Like, you're supposed to let the class know what the rights are, what the remedies are, what the state of the law is, and what the outcome of the settlement might be, and how that is to be favored or not favored by the class. Like, they have a right to know this stuff. They're bound as a matter of law by this ruling. And the 11th Circuit Court of Appeal found, and I think properly, that class counsel screwed up, GoDaddy's counsel screwed up, and ultimately even the district court screwed up in authorizing notice that did not provide the right amount of information for the class. Incredible ruling. Again, I cannot emphasize enough how powerfully worded this decision is, how critical the 11th Circuit Court of Appeals was for class counsel. May I live 1,000 years and never face a ruling as brutal as this one was. It was really, really tough stuff. And I'm telling you, not only is it very bad for GoDaddy and for the plaintiff's lawyers in that case, it's really bad for the entire TCPA world because it changes the paradigm, right? For 10 years now, we've had a paradigm. You roughly knew what a TCPA settlement was going to cost you. If you were a big enterprise, you had 4 million people in a class, you had 10 million people in a class, you had 100,000 people in a class, it was a wrong number class, it was a pre-recorded class, it was a D&C class. You knew, based on these basic pieces of information, what jurisdiction you're in front of, right? You knew what the price of poker was. You knew the range. In fact, I could pinpoint almost to the dollar. Just give me 5 or 6 data points, I would tell you exactly how much that case would settle for. But now, after this Drazen decision, all that playbook is out the window. Now it is incredibly difficult, even for a guy like me who's very seasoned, who's done, I don't hide. I've been the architect behind over a dozen class-wide settlements for major institutions because that was in my client's best interest, right? I don't hide that. That's public record. But now we've got a situation where the paradigm, maybe even very similar paradigms to what I've done in the past, is now completely thrown out. You can't do this anymore, right? In fact, the court found it was collusive. So how do you structure a settlement in the brave new world of a TCPA case where reversionary common funds they're out the window, right? Where you have to look at the actual amount paid. If these plaintiff lawyers want $3 million in fees, you can't just pay $500,000 to the claimants and walk away at with $3.5 or $4 million on a settlement for 1 million people. Now, the class has actually got to receive that 10 million, 12 million in value for the plaintiff's lawyers to get that $3 million. So what's going to give? Are the plaintiff lawyers going to accept less money on these settlements, or are the defendants going to have to cough up $12 million in a case that would have usually cost them only $4 million to settle? I'm going to tell you, it's probably not the latter. That means the plaintiff's lawyers are going to have to start accepting less money in these cases, which might mean that there's going to be less of these cases. So that ultimately might be the punchline, right? And again, this is going to take time. This is not going to resolve itself in a couple of weeks, a couple of months. It's going to be years before we really feel the outcome of Drazen, like how it actually shifts the marketplace in the TCPA world. But there is definitely the potential that this ruling serves as a brake on future TCPA class action filings right at a time when those filings are spiking higher than they've ever been historically. Thoughts?
That was a lot, and it's a lot to process. I mean, it's interesting what you just said right now of TCPA filings, on the peak right now, especially coming into January 2025.
60% year over year from last year. 60% increase this year so far.
It'll be interesting to see, how seriously plaintiffs' attorneys are actually taking this ruling, if at all.
I've talked to a couple.
Okay.
I've talked to a couple already. They are playing it down, as you'd expect.
Yep.
They're saying, oh, it's a coupon settlement. Oh, it's a CAFA issue. I mean, they're trying to play it down, but I'm here to tell you, no, this is much bigger. It's much bigger than that.
Interesting.
Yeah. All right, well, so there you go. Ladies, any thoughts on that before we pivot, move on? No?
No, when I read the opinion and after you blogged about it and read about it too, it's like, as an attorney, you never want to be presented or looked by a court in that way. So that's just very scary.
Yeah, scary. Yeah. No,
That's a good point, Britt. The first thing I did was go check who it was.
Yeah. And you see, we don't name the lawyers. We're not going to name the lawyers, but it's public record. You can find them.
Yeah.
All right, Britt, what do you got for us, partner?
Yeah, so speaking of having Andrew Perrong on the podcast, and as he's known as being a serial litigator, I actually have a case involving another serial litigator. His name is Thane Charman. He filed a suit against Desert Group, alleging violations of the TCPA. He also sued two guys individually, Ryan Hogan and Chris Armstrong. So in response to the complaint, they both, obviously, as you'd expect, moved to dismiss the complaint. Hogan argued that the court lacked personal jurisdiction over him. So he said, the case was filed in California. He said, I don't live in California. I actually live in Canada, and the plaintiff can't provide any evidence to subject me to jurisdiction here. So the court was convinced by that argument, and thankfully, his motion was granted. As to the other defendant, Armstrong, he also moved to dismiss, arguing that there weren't sufficient allegations in the complaint tying his direct involvement with the calls at issue. So thankfully they got off scot-free, but this just serves as another reminder that there is personal liability under the TCPA, whether you are a CEO or you're in a call center or have any involvement with the calls, that to take this statute seriously, because you can be named in lawsuits like this.
What was the Canadian guy's name?
Ryan Hogan?
Ryan Hogan. Do you think Ryan Hogan went and had like a maple donut to celebrate and watch
something, whether it's maple donut or something else?
Yeah, he was like, this is just what I want. I don't know why I'm picking on Canadians. I love Canadians, and but okay. Well, great breakdown. Yeah, personal jurisdiction. Never lose track of that, right? If you're getting sued in a far-flung jurisdiction, many times you can argue that you can't be sued there. It's something really powerful to keep in mind. And this other gentleman, look, way to push it. These guys have the obligation to allege facts demonstrating that you are personally involved before they can sue you personally. And guys like Charman, they like to sue individually. I hate it. I think it's Bush League. And no one does that to our clients. And, I'm telling you right now, Charman and everybody else, don't do it. Don't do it. We will make your life, we'll make you regret it, because it's not appropriate. You shouldn't be doing that. Now, look, there's some instances where it's fine, but, where you've got a real company, going after corporate officers, I think that's just very Bush League. But thanks for the breakdown. I appreciate that. Blondie over there, what do you got?
Well, I have a few new AI laws out there.
Oh, yes, little Miss AI. Yes.
So, first one is New Mexico. New Mexico is now requiring on political advertisements, whether it's print, on the radio, anything of that nature, where if AI creates any part of the political advertisement, that you have to disclose that conspicuously on the advertisement. And if you don't, there's criminal penalties.
Oh, I love that.
First one's misdemeanor, second one's a felony. So
Makes sense.
No private right of action at the moment, though.
Interesting. Okay, what else you got?
The other one is Utah. Utah, you now have to disclose under certain regulated industries and for certain interactions, especially when prompted, and when prompted by all means, that generative AI is being used. So this has to occur prior to the communication. So let's say I'm on a chatbot for a hospital, which is one of the regulated industries, and they're using AI to run that chatbot. They would have to say, this is generative AI being used to speak with you.
Fascinating. I love that, and thanks so much for that breakdown. In New Mexico, why is it only political messages? Any idea?
And just right now, it's political messages, probably because of the New Hampshire issue with Biden. A lot of states are now taking that pretty seriously. I see a lot of them popping up. This was just the first one that kind of went into effect, especially the first one with criminal penalties involved.
As a former prosecutor, what do you think about that? Would you want to prosecute those cases?
I mean, they seem pretty easy to prosecute, but
There you go.
I don't know if it's the best use of time these days.
Well, so now are you looking forward to LCOC, the Law Conference of Champions, where AI in the afternoon will be put on by Tori the Dame Guidry, following in last year's footsteps? You did such a good job. It was probably the most talked about session last year was the AI session, and now you've got it again this year. Are you looking forward to it?
I am looking forward to it, and this year there's so much development that happened. It's not just theoretical this year, it's serious threats that people need to be aware of, that they need to take into account to make sure their businesses are compliant, and to make sure in some states they don't end up in jail.
Are you on board, by the way, with LCOC as the acronym as opposed to LCOC? We fought about this for a long time, LCOC versus LCOC. I think we landed on LCOC. You were one of the holdouts that was for LCOC. Where do you stand today?
I think being complacent at this point.
There you go. Yeah, LCOC has taken over. Thoughts?
You said we all agreed on LCOC. Do you have a monkey in your pocket?
Key in my pocket.
LCOC. Yes, we are very excited for LCOC.
You serious? You're gonna turn traitor on me? You were one of the biggest advocates for LCOC. Oh my God.
I'm an advocate.
Oh, this is madness. This is madness.
All conferences of champions, folks. Can't wait to see you in July.
All right. Well, what do you have, Little Miss Turncoat? Goodness.
This one's interesting, just because I love when folks talk about Twilio and all the bad acts that they're allegedly doing, call blocking, and all the things that my clients are always frustrated with when it comes to platforms like Twilio. This one's, an interesting case. It's brought to you by Abbas Kazarunian, the godfather of TCPA world. So anytime he's filing cases against platforms, especially those like Twilio, I'm very interested. So Plaintiff Anthony filed a case against Twilio alleging that he had asked repeatedly to Twilio's paralegal and their litigation counsel for calls to be stopped by numbers owned by Twilio. Really interesting because, as we know, the TCPA's CFR provisions allow you to have rights if your number to put your number on the DNC list, on someone's internal DNC list. Now, the TCPA CFR regulations don't allow you to have numbers completely blocked from calling you, right? So the entire case is premised on having Twilio block phone numbers that are, stop calls to a phone number that are owned by that one phone number. So, I mean, it'll be interesting to see how the court rules here, but kind of doesn't make sense to me. I'm with Twilio on this one, because why should Twilio have to ban an entire network of phone numbers that are owned by them from calling you, right? The DNC belongs to, the DNC is towards the entity that's calling you, not the person that owns the phone numbers.
Yeah, and to be clear, I mean, for most of you know who Twilio is, but let's imagine some people that don't know what the heck Twilio is. Twilio is a platform, right? Twilio facilitates communications on behalf of third parties. The third parties are the ones calling you. It's it's Bob's Allstate company that's calling you. It's not Twilio. Bob's Allstate company is using Twilio to send the message, but Bob's Allstate company is calling you. And this oddly would require Twilio to ingest a do not call and then prevent any of its tens of thousands, hundreds of thousands of users, right, from ever communicating with that number again, which just makes no sense if you think about it.
How would they even operationalize that?
Well, I mean, that Twilio could figure that out. They could just, have this number in their pipes and prevent any outreach from any of their DIDs.
So it wouldn't really be that difficult.
No, technologically it wouldn't be difficult, but it would be absurd because, if you're Bob's Allstate and they don't want to hear from Bob's Allstate, but you're a Dish Network and or you're the guy's bank, right? You're Wells Fargo and they've got a bank account there and they're trying to send you a message because someone hacked into your account. The fact that you didn't want to hear from Bob's Allstate doesn't mean that you don't want to hear about that fraud notification. The law does not require anybody to treat one revocation as a revocation of all communications across the entire platform.
It begs the question of whether that revocation is even reasonable, right? Asking Twilio. So I'm actually just surprised that Boss, out of all people, are bringing this case. So I'm wondering if there's something else there that we're missing. I mean, this is just a complaint so far. It hasn't gone past, there hasn't been any motions being filed. I don't know, obviously, the background facts here other than what's alleged in the complaint. But Boss is bringing it, so it's not a class action. So, it's serious, but not that serious yet. But who knows? Maybe more of these class actions will start being filed against platforms.
I view it as like it's two pieces, right? Piece one is what you just laid out, right? The universal do not call provision argument, which I think is garbage, and I agree with you. A boss, like, what are you doing? That's a bad argument, dude. Don't do that. But the other argument, which is fascinating to me, is the platform liability, the Twilio liability for carrying bad illegal traffic, right? So set aside the universal opt-out for a second. Let's say that we knew Twilio was told, or Twilio ingested a stop message to Bob's Allstate, right? But Bob's Allstate switches phone numbers and keeps hammering him on Twilio using a different DID. Twilio is going to be charged maybe with knowledge that took place, right? Ought not Twilio be held liable for facilitating that illegal conduct by Bob's Allstate? To me, that answer is a much closer call, right? I'm not saying that I agree with the boss or that I agree with Twilio, but I see the argument there. The universal opt-out is baloney. It's garbage. I hate that argument, and again, I'm surprised that that's being brought. But can Twilio be liable where its user is switching tactics, switching phone numbers, and perhaps, the DIDs are being supplied by Twilio, right? Can Twilio, with actual knowledge of this misbehavior, be charged with, these violations as if it was itself the initiator of the call? That is a closer call from my perspective. That is what I'm most interested in, because if the answer to that is yes, Twilio will be in a world of hurt, because at the scale that they operate, I can guarantee you they have millions of violations. And again, I'm not saying they're doing anything wrong. Even if they're best in class, top of class, and they probably are, the scale of the billions of messages that these guys carry monthly, I believe that that's accurate. I believe it is literally billions monthly that traverse the Twilio pipes. The scale of that is such that even if you have a 1% error rate, even if you have a 0.001% error rate, you're still talking about billions in liability every year being created. And so this is a really big deal. The stakes are very high. I don't care that it's not a class action. It only takes one of these. If a boss wins this case, Twilio is going to get eaten alive. Just my opinion.
And more importantly, I mean, the FCC is going to eat them alive as well, right? The FCC, as we know, we've seen them repeatedly look at platforms to see if platforms are encouraging or are knowingly encouraging the bad behavior of the platforms, right? So the FCC is going to be asking the same question that the Czar just asked you is, did Twilio know of the bad acts that are being facilitated here?
Fascinating question. I know Whitetail got in trouble with that a while back. All right, well look, this has been great, but let's get to the meat. Let's get to Andrew Perrong. I'm looking forward to it. And so now, through the power of the Troutman Amin LLP law firm, we bring you an exclusive interview with Andrew Perrong. Now, through the power of the Troutman Amin LLP law firm, we're very excited, always a little nervous though, to bring on Andrew Perrong, former TCPA professional litigant, now pretty good lawyer out there making some noise in TCPA world. Welcome back to the show, Andrew.
Well, thank you for having me.
Yeah. You are officially the first person that we've had back a second time on the Deserve to Win podcast. And, I have a little bit of trepidation about having that be you, Mr. Perrong. But I have to admit, you've made some noise. There's been some headlines that you've generated, both good and bad. And so I think in light of that, it was appropriate to have you back. How have you been?
It's a pleasure and an honor, and it's been great. I mean, we've been 6 months into the legal career, and things are going great.
Yeah, let me ask you about that actually before we dive into the specifics of some of these new cases. Like, how many filings do you have? It's all public record. If you could just kind of give us a sense, like, what's your volume look like? How's it been going? You got some settlements. You've got obviously some wins and some losses we're going to talk about. But can you just, like, at a high level, kind of talk through how's your practice going?
Practice is going well. Right now, we're sitting at about 50 cases with the firm, either directly or through co-counsel. So, and we're always looking to bring on some more. So, we're not done yet.
All right, pretty good. 50 that's a pretty strong number. And are these all TCPA, or are you doing kind of other kinds of cases, or just TCPA right now?
TCPA for the most part. We've got some other actions that we're doing, but all consumer protection TCPA primarily is the focus of the firm.
Okay, and you know what? I'd be remiss if I didn't ask. The hair, like what's going on, buddy?
I just thought I'd change it up a bit. So.
I'm not gonna lie, it doesn't look bad. I'm not going to say that it looks good, because that could be viewed as encouraging litigation. But it doesn't look awful. I'll be honest with you. If I hadn't met you before with the previous hair, I would think, yeah, this is a good look. This is the way this guy should look. So there you go. It's not like Tori, who she changed her hair, and like a year later, I'm still like rubbing a little salt or on my own wounds, I guess, because I miss her being redhead. But okay, so you mixed it up. This wasn't like a bet you lost or anything. You just decided to frost the tips.
No, just decided to frost the tips, going back to the 90s.
I was going to say, it's very boy bandish.
Exactly. I've gotten that quite a few times.
That's fair. Look, we say around here we're bringing sexy back, so you know we're vibing on the JT front. What was he in? Was he in sync, or was he a Backstreet Boy? Does anyone remember these things? He was in sync. Okay. So Andrew's got kind of like the Lance Bass thing going on. So you know what I'm talking about, right? Look at me just like pulling out these names. All right, cool. So now let's get past that. So let's talk about a couple of cases, Andrew, that you've been involved with. I'll start with your big win, and then we'll talk about your big loss. Really, really fascinating case. I definitely want it from your perspective. I'll tee it up at a very high level. This is the Bradford decision out of, what was this, the Eastern District of Pennsylvania, I believe. Fascinating ruling. Again, I want your take on this. I want you to break it down in your own words. As I view the case, though, at least at a high level, you're talking about governmental officials being potentially held personally liable for official communications by their office that have been cleared by the House Ethics Committee in that case, seemingly to be a nonpartisan, non-campaign related communication. Really fascinating ruling, Andrew. No case has ever come close to this. Definitely created some new law here. Would love your take. What's going on?
I think, well, the results ultimately speak for themselves. The better argument at summary judgment won at the end of the day, and I don't really take credit. I'm not the greatest attorney, but I wrote an argument that was compelling and convinced Judge Wolson that saw it my way and not theirs. And really, I think ultimately it's boiled down to the first paragraph of that opinion. You know, if you call people, you have to call people with consent who, like Blondie say, call me on the line. Bit of channeling my inner Blondie here, but
that was way too on the nose. I love it.
But I think ultimately, you know, legislators should know better, and this shows how bad of a problem pre-recorded robocalls are. And you know, obviously now this is going up to the Third Circuit, and they're still going for the immunity angle. But I think that the judge was right in his assessment in seeing this case not as an immunity case or as a governmental calls case, but as a case by an individual legislator personally recording messages and directing them to be sent. And the judge made a very cogent point in that regard, to where there's no rule of the House of Representatives, there's no government rule that requires him to send out robocalls. He has a number of other methods of communications available to his constituents. He can still call persons who have expressed a desire to obtain robocalls. And literally just 2 days ago, I received a call from another Pennsylvania state representative. So it's essentially giving, you know, just the court's decision is falling on deaf ears. And ultimately, you know, I think that legislators are not abiding by the TCPA, and, you know, are not following the judge's assessment here that these are individual calls made in individual capacities without any sort of needing to go down any sort of immunity angles or anything like that. I think the liability under the TCPA is quite clear. 47 USC 227B1A Romanet 3, as Judge Prater likes to say.
Well, look, it's interesting, Andrew, because from one perspective, maybe the case was correctly decided. Maybe it is as simple as you just laid out. But there's a few permutations to this, and I'm gonna walk you through each one of these, and feel free to absorb or pivot away as you must. I understand you're still in active litigation. There's an appeal pending, and so I appreciate you even coming on to talk about this at all. Right? Many people wouldn't be brave enough to do that. You're very brave to do that. So again, I understand if you can't answer specific questions. But first, let me just ask you, what were the messages? I mean, weren't these messages something really basic, like, hey, come out and join a fair where you'll hear about free medical options that might be available to you through government services, or hey, COVID is still an issue, come take advantage of an inoculation program that might be available. I mean, weren't these public-friendly, consumer-friendly, helping people sorts of messages, or was there something else to it that I'm missing?
Well, I think that the messages, the text of the messages are in the opinion. I think, one of them was to advertise an event at a fair, or rather at a zoo. One of them was a COVID-related call. But I think that the point is, it doesn't matter whether or not they're good for consumers or not good for consumers. It's whether or not consumers want these calls to begin with, and whether or not they want to be disrupted. If they sign up for such communications, and if they want to get these communications from their legislators, that's one thing. But just to blanket call everybody in a certain area code or in a certain geographic area and just blast them out, I'm not even his constituent. So just to blast out these calls to anyone and everyone, seemingly, that doesn't request them and very often disrupts my own flow, my own day, I think that regardless of the message or the benefit there, the harm here to consumers is far worse than any sort of benefit that might even be from the call, because of the very fact that they are so disruptive and that they are so unwanted. But
look, it's a brave position, Andrew. It's a stark position where you've got messages seemingly trying to help elderly people get health care, or seemingly trying to get folks to be inoculated so that they don't die from a dreaded disease. Some would argue that might even fall within the emergency purposes exemption. Some would argue that this is very consumer friendly. But your point is stark, and it's clearly made. Look, no, right? There's a nuisance component to this, and you're not going to tell me that the salutary benefits of whatever it is that robocall is pitching are sufficient to undermine the legislative intent behind the TCPA. That's cool. I'm not going to battle you there. That you've staked out your position, and I respect it. But is it not the case, because this is where I really struggle with the opinion, is it not the case that the FCC has twice, both in the Broadnet and in the reconsideration amended Broadnet order, confirmed that official state and federal communications are not subject to the TCPA because the government is not a person under the Act? I mean, you would agree with that very simple premise of law, wouldn't you?
Well, actually, in the briefing on summary judgment, I took essentially two positions, one and then another one in the alternative. And the position I took with respect to the Broadnet ruling is it's merely an interpretative rule. It doesn't have the force of law, a la PDR network. And I think that especially with the Supreme Court's maybe overruling of Chevron, that will result in all FCC guidance being interpretative rules, which would mean that the Broadnet order does not have any, it's merely advisory, and to the extent that it conflicts with the plain language of the statute as informed by traditional tools of statutory interpretation, those traditional tools of statutory interpretation should control over any sort of ruling that the FCC comes out with.
All right, but now look, the word person, right, is defined in black and white not to include any governmental entity. That was the interpretation that was adopted by the FCC as a plain reading of the statute. And although you say under PDR resources this is not meant to be a legislative ruling, was this not both the original and the amended pursuant to a formal NPRM proceeding in which comments were built? And this looks to me to be a full legislative action consistent with the APA. So from my perspective, I know you just told me one of two arguments. From my perspective, that first argument, it dies on the vine, man. Like, sure, if PBR Resources and the Supreme Court overturns finally Chevron, overturns again, takes a look at Hobbs Act, but that hasn't happened yet. Under the current paradigm, the word person does not include a governmental entity according to what I would consider to be binding law from the FCC. Now, your second argument, which I know you're going to get to, was very smart, and it actually pivoted away, and it basically said, to summarize, and again, I want your words here, but my understanding, what the court ultimately decided was that whole ruling is irrelevant because the person making the call wasn't the government. The person making the call was Bradford. And that's the twist here, right? That's the big twist. And go ahead and break it down from your perspective.
Well, I think from my perspective, in terms of the FCC's ruling that a person does not include the sovereign, it's at odds with the plain reading of the Communications Act, because state governments and state and local governments are still subject to, for example, FCC licensing requirements. A state government, if they're building, for example, a public safety radio station or a radio network for police dispatch and whatnot, they still have to get the FCC license. Because that is within the federal government's authority to regulate a modality of interstate commerce, which is, of course, the communications and airways and wire communications. So to that extent, I think that the reading that the Communications Act does not include a sovereign is at odds with the statutory text and other areas of the Communications Act where governments are required to obtain licenses. And why shouldn't that apply to the TCPA?
Dormant Commerce Clause and statutory interpretation from the text. Come on now. Andrew, don't make me answer these rhetorical questions, but get to the good argument, which is not this. This is all bad arguments. Save that for the Court of Appeal. The good argument was the person making the message, making the call. I want to hear that.
And again, if you're personally recording a robocall and you can direct anyone to send that robocall, but if you're personally recording that call, you are authorizing its sending and you are authorizing its content. The fact that you seek approval from one place or another to send a call, it's irrelevant to the fact that you are the one ultimately initiating the call and setting it in motion and making it, and thus you should be liable under the TCPA. And that's fascinating. Yeah, that's the fascinating argument. And that's the one the judge bid on like hook, line, and sinker. And basically everything else, all the other analysis, all the FCC work, all the sovereign immunity, it all goes out the window to that one little sleight of hand move. No. The government didn't send this. Bradford sent this, period. And in my view, look, I didn't go and dive into the briefing. And again, you don't have to characterize this if you want or don't want. I didn't go into the briefing. But to me, the biggest miss from the defense side, you know me, I always pick on the poor defense lawyers, was the line where the judge essentially said, apparently nobody disagrees that Bradford himself sent, at least not at this stage, nobody disagrees that Bradford was the sender of the message. And the entire rest of the analysis flowed from that one basic premise. Bradford was the initiator. He was the maker of the call. And once you accept that premise, right, the court just looked at whether or not he was a person. Yes, he's a person, and I don't disagree with that, right? He's a human being. He's a person under the statutory language. So that was step one. And step two was just looking at qualified immunity. Now, qualified immunity, I would definitely argue that the law is not set for the same reason we talked about before in the broadnet piece. But again, if you accept the premise that Bradford was the sender, the government wasn't the sender, I mean, I understand in a narrow, intellectually honest way why the judge came down, right, waterfalling all the rest of the analysis, but it all starts with that one premise. And from my perspective, that's highly questionable. But you definitely got that done in this case. So I'm just curious, like, is that your focus on appeal? Do you think the record supports your position that Bradford was the individual sender? Do you think that might be an issue in the future, or maybe you can't talk about that? Well, I mean, obviously, I think that we have to see how the briefing comes up. I think, to begin with, I think that the Third Circuit and the Third Circuit's indicated that the appeal is already questionable because it's not, in their mind, it seems not to be a final appealable order. It seems to be a interlocutory appeal for which they didn't seek leave. So the Third Circuit's ordered supplemental briefing on that issue as well. Again, if we take this court's reasoning to its logical conclusion, if immunity doesn't really apply here, then there's no appeal yet, and the order is not appealable unless it's interlocutory. I think that it remains to be seen how that shakes out, and obviously if that doesn't shake out in my favor and the Third Circuit allows the appeal to go forward, then I'm sure that the bulk of the Bradford's argument is going to be that the court got it wrong on the immunity angle, and that's where the Third Circuit should reverse. So I think that then would go. So I think that the strategy in this case and in this appeal is going to be dictated by how this interlocutory appeal issue shakes out, and B, once that shakes out and if it goes forward, how that briefing is going to be presented.
Let me just ask you the narrow question, and again, feel free, you've done a great job answering the questions, but you don't have to answer any of these. I know it's on appeal. How does the narrow issue of the maker of the call being Bradford, as opposed to the government, inform or perhaps even decide the immunity question?
Well, I think that it's quite clear. He recorded the calls. There's no dispute that his voice is on the calls, and he's liable. Immunity doesn't even come in because he's failed at step one. He's a person. He's made the calls. He's recorded the calls. There's no dispute as to that. And therefore, he's liable under the plain text of the TCPA.
And this is where I struggle, because the immunity test looks at whether the doctrine of law and the rights that are being impacted were preserved. It doesn't look at the subjective mindset of the sender or the actor in terms of whether or not they are acting on their own behalf or somebody else's, i.e. the government. So as much as I hate to agree with you, I really think the entire analysis flows from that single premise of who is the sender of the call. And once you accept that Bradford is the sender, man, the judge might be right all the way down. I just don't know that the Third Circuit reverses this. And I hate to say that, Andrew, because I'm not rooting for you. And I really think, and again, I say this with love to the good judge, I think the case is wrongly decided. I think the case is wrongly decided, though, because an official communication of this sort is a governmental communication. Full stop. This is the state of Pennsylvania sending a message to voters, to individuals who are in the welfare of the state, right? Individuals who need assistance that the state is providing. It is a state communication, and therefore it fails at step one. The state is the sender. They are not a person. Therefore, Bradford is the wrong target of the case. That's just my opinion, right? To me, that's the strongest argument that for some reason has not been raised. At least the judge found it wasn't raised properly at the summary judgment phase. But I don't see how the appeal reverses that issue, and I assume you agree with me.
I would, and I think that the one point that the judge made here is that there's a distinction here between, for example, some state employee being told as part of their employment to record a pre-recorded message, for example, telling persons that their taxes are delinquent or something like that, and then sending that out and then being liable because they're acting under the orders of the Commonwealth of Pennsylvania to send out those messages. Here, Bradford was not acting under an order of the Commonwealth. The fact that the Commonwealth has rules and regulations in place does not change the fact that he is not being required in his capacity as a state representative to send robocalls. So I think that is a personal decision on his part. For, again, there's no subjective, to your point, in terms of the immunity angle, it doesn't look at the subjective test. It looks at whether or not the action broke a clearly established statutory right, and he, in his individual capacity, decided to send these calls, which violated a clearly established statutory right.
Is his subjective mindset relevant to the immunity question?
I don't think it is. I think they're probably going to try and argue that, and that'll certainly be something that we can evaluate at at the Third Circuit, but I don't think that his summary or his subjective intent at all matters for the purposes of this analysis.
To me, I think that's the only question open on this appeal, just kind of narrowing it down. If his subjective intent is irrelevant, then I think you win. And I hate to say that. I really hate to say that, but I think that that's the case. So, okay, let's pivot off of this. Thanks, Andrew. You've been very good and very candid on this. Again, very brave. I'm saying that very seriously. Like, very, very few people would come on with a pending appeal and like share their side on a podcast, listening to Troutman ask him questions live that he was not prepared for. And you're doing it, and you know what? You're doing a good job. So let's pivot over. Now that we've talked about your win, now I'm going to have a little more. I'm going to have a little fun. Let's talk about your big loss. You just had a case up to the Third Circuit Court of Appeal, an ATDS case. And last time you were on, you told me you liked these ATDS cases. And this Third Circuit opinion, man, it just obliterated you. Took out the footnote 7 argument. Found very clearly that the system at use was not an ATDS. But why don't you explain the ruling from your perspective rather than just have me characterize it at you?
Yeah, I mean, obviously, I think that we now have the Second Circuit's decision in Solomon, which essentially adopted the same reasoning as the Third Circuit. So now we've got the Third, Ninth, Eighth, and Second Circuits against the consumer and holding that you must randomly generate a telephone number in order to be an ATDS. I think that the Northern District of Illinois seems to think otherwise, so I would be interested to see, for example, how Judge Easterbrook might, if he's on the panel, to see how that might shake out. But as well, I think it makes it so much more important for why H.R. 7116, the Do Not Disturb Act that Representative Pallone is introducing, really needs to pass, because it really resolves this issue of law that, you know, as you've mentioned, the Third Circuit has ruled against me on, but it clarifies that statutory definition and clarifies that dialers that use that dial randomly or sequentially, but from a list, are still ATDS systems.
For the record, I think the Eighth Circuit Court of Appeal is a slightly different issue. It looked only at the issue of producing numbers and determined that that action had to take place using a randomizer, not storing numbers, whereas the Second, Third, and Ninth are all aligned now that storage still means you have to randomly generate telephone numbers. So those three circuits have rejected footnote 7 of the U.S. Supreme Court's decision in Facebook head on, whereas the Eighth Circuit has not. So I just want to clarify that. But let's focus still on the Third Circuit ruling. I want to talk a little bit more about the background, and I can break it down, but I'd rather have you do it. Like, who were you suing? What did they do wrong? What was the theory, and why did you bring it up on appeal?
So the calls were ATDS calls in my assessment, and as I pled. Essentially, it was 4 calls from a local Democratic committee. I did not answer 3 of the calls. They went to voicemail. No voicemail was left. They occurred at exactly the same time every single day for 4 days straight. The 4th day, I answered the call, said hello, waited about 20 seconds. There was then an agent came on the line, wanted to request something about a mail-in ballot. Told him, hey, I wasn't interested, and found out who it was. But because the call was so disruptive, I ended up suing on that. They filed a motion to dismiss. They said that they were calling a list of registered voters, and thus, even though they were calling the list sequentially, even assuming that was true, that they did not use an ATDS, the district court agreed with them. Third Circuit affirmed. So that's where we stand now, and the Third Circuit essentially has held that you must randomly or sequentially generate a telephone number itself. You cannot randomly or sequentially generate a number from a list of numbers. It has to generate the number itself randomly or sequentially. So that's the state of the law, and we'll see how that works out. But like I said, I think that where most of my effort is going to be focused now is toward that legislative solution, now that the judicial solution sort of dried up.
You're not going to take a writ up to the Supremes?
No, I'm not planning. I'm not planning cert.
Okay.
I've heard rumblings that that the Second Circuit Suleiman decision might go up on cert, but I'm not planning a cert petition for that.
Well, it's tough because there's no split right now, right? So I don't see the Supremes, even though, look, I'll be honest with you, I'm already on record saying I do not believe the Borden decision, which is the Ninth Circuit ruling, which is the one that started it all. I don't believe the Ninth Circuit's opinion in Borden is correctly decided. I think that the Supreme Court spoke very clearly otherwise, that there's an or, right? That the phone number, the statute says that you can either produce or store telephone numbers to be dialed using a randomizer or a sequential dialer or sequential generator. And that's not what Borden says. And of course, Suleiman has now followed Borden. The Perrong case out of the Third Circuit. Ooh, how's it feel to have your name on that one, Betty? That can't feel great. Is in accord. So there's really no split of authority, even though, in my opinion, all these decisions are frankly wrong. And look, I'm a defense lawyer, right? So I'm going to use these. It's not like I'm not going to leverage these cases. Of course I am in favor of my clients, although no one brings ATDS cases against my client, any of my clients. But at the end of the day, I think legally these opinions are not consistent with what the U.S. Supreme Court actually said and did. But I don't think there's going to be a cert approved in Suleiman just because there's no split of authority.
Solomon did have that. Sorry, but Solomon did have that dissenting opinion, and I think that there's also some rumblings in district courts. I think that obviously the Northern District of Illinois seems to think otherwise. You've got the decision in California in the name escapes me, but something versus the United States. It was another Facebook case where I think they called Borden a confusion sandwich. So I think that there's some rumblings of authority, and obviously the legislature is also aware of this issue and lack of clarity in the law.
I don't, going back to the Pallone bill, that bill is a mess, man. I cannot even remotely support a bill that is as poorly worded as that is. Even if I were, wanting to be consumer friendly, wanting to, and look, I've stopped more robocalls than any human being alive. Like, no one is more committed to stopping unwanted robocalls than I am. But you have to do it in a way that is logical, that people can comply with, that doesn't convert every single phone call anyone's ever made into a robocall. And the definitions, particularly of text message in that bill, absolutely incredible, man. Like, any message that's ever been sent by anyone at any time is now a robocall. I mean, it brings everything you do within the ambit and regulation of the federal government. I mean, this is not what we want. This is not good for society. Now, I don't disagree that maybe some legislative, call it a fix, might be appropriate at some point in some way at some stage. But what is on the table right now is garbage. You don't have to agree with that, but I mean, I look at this and I'm like, this is, to me, there's no question that this is the wrong approach. There might be a different approach that might be the right approach, but what is on the table right now is just garbage, in my opinion. All right, Andrew, look, man, you've been more than fair. Like I said, you've been very brave. I actually respect you coming on here talking about these pending matters like this. What else you got, man? I'll give you a couple minutes. What do you want to advocate for? What's on your mind?
Well, I'm starting another blog called TCPA Talk.
I knew you were going to bring this up. The Avenger, right? All right, go ahead.
But I'm following in your footsteps, but providing a plaintiff's perspective on the TCPA.
Oh, boy.
Well. So we're doing that. Really, like I said, we're not really pursuing the ATDS cases. We'll see how Bradford shakes out. There might be some additional cases in that vein, but I don't have anybody on deck at the moment. But yeah, it's been great. It's been a great 6 months, and I look forward to working with you, and look forward to working with all members of the defense bar and whatnot to, I've yet to see it, but I will give you the benefit and see, if you say that we're on the same team for stopping unwanted robocalls, I'd love to have your support as well.
Well, look, I'm the president of REACH, Responsible Enterprises Against Consumer Harassment. We've pledged to adopt standards that will stop 1 billion unwanted calls a month. We've done a great job moving toward that goal. But my previous life, right, serving as compliance lawyers for some of the biggest banks in the country, I'm telling you, nobody has stopped more robocalls in terms of like getting companies that were very errant in their practices to understand what the law requires, clean up on an enterprise basis, and basically go from making 10 billion robocalls a year to making, 500 million, and all of them consented. I mean, you're talking about tens of billions of robocalls I've single-handedly stopped over the course of my career, and I'm very proud of that record, of course. But at the end of the day, what we're doing with Reach is an entirely different concept. Where we're trying to take the entire industry and make them, do the right thing. It's just, no one's ever done anything quite so ostentatious, so aggressive as we're attempting here. And of course, we want to do it without the government's involvement. Every time the government gets involved, it's always for political grandstanding. It's always for effect. It's always, more for what they can cash in with the voters in terms, as opposed to like what actually is good for people. And so we're trying to do things the right way from the ground up. I know you guys on the plaintiff's bar, you're out there serving the purpose to some degree, although I dare say I think you're mostly serving yourselves. I say that with some degree of respect. But you are more of a true believer than others. I'll give you that. There are others who I won't name who are horrifyingly cynical and will just admit behind closed doors that it's all a game and they're just there to make money. That doesn't seem to be your game. I mean, you seem to actually be committed to this and dedicated perhaps to a fault at times. But I can appreciate again the pristine nature of your pursuit.
Well, I definitely appreciate it. And I think that you bring up an excellent point, and that is, I see in the next 6 months, I think that the big battles are going to be fought on the fraudulent lead generation angle. I think there's a lot of, and I said this our first time, and I'm seeing more and more of this. I'm seeing a lot of bad actors, especially overseas, that are generating leads in non-compliant ways, and companies are purchasing these leads, either knowingly or unknowingly, but they're purchasing these leads. And I'm seeing a lot more client intakes where there's at first what looks like to be a legitimate opt-in or a legitimate lead, but as soon as you start digging and following the trail of these overseas entities, it starts falling apart. So I think that's really going to be where a lot of the battles are going to be continuing to be fought. So I think, to the extent that you're stopping unwanted calls, I think that also needs to be part of the strategy and working toward having companies have compliant processes in place to ensure the integrity and legitimacy of the leads that are purchasing.
That's what we do every day, man. Well, hey, listen, Andrew, I really appreciate you being on. And again, you have the honor of being the first person ever to be on the show twice. And it's because you made some big rulings, right? And you keep going out there and making big rulings, taking big swings, and maybe sometimes you win, sometimes you lose. But we'll have you back because I like talking to people that are making waves. And look, man, you're making waves. So good job. Ladies, do you have anything for Andrew? Okay. Well, man, thank you so much for being on it. We really appreciate it. Thanks, man.
Thanks.
Wow, I really did not believe that Perrong, of all people, was going to be the person that we had on like a second time. But he's out there, he's making some noise, he's causing some trouble. So, I guess it makes sense. Tori, why don't we start with you today? What did you think?
Well, I thought it was excellent that he's following in your footsteps and my footsteps as well.
Oh, God.
TCPA talk.
What does that mean exactly?
He's starting TCPA talk, just like you started TCPA World, and the frosted tips, man. I think he got that idea from me.
Yeah, that's actually true. He's spending a lot of time, I think, absorbing like deserve to win content. I'm trying not to raise the whole TCPA talk thing because I looked at it and sorry, Andrew, it's just not up to snuff yet. It's not quite ready for prime time. I'll start talking about it, even linking back to it, like once it gets, maybe a little bit more content or maybe content that's a little bit better kind of thought out. And of course, now the way I talk about this, now people are going to go read the whole thing, and that's exactly what I wanted to avoid. But it's fine. Go check it out. But no, I like it. Like I like that he's trying to, do that and kind of bring his own perspective to the table and have his voice heard. I'm very supportive of that, and I'm very supportive of people not living in an echo chamber and hearing both sides of any topic. So from that perspective, I'm glad that he's out there doing it. And we'll see where it goes. That's it. You were just excited that he's basically frosted his tips. That was all.
No. Also, I think it's interesting to see the difference with him this time as from last
last time.
He's grown up a little bit.
He's
huh?
grown up a lot. He's much more well-spoken, much more pointed. I think, he's turning into a decent attorney.
He was forming complete sentences, and it was pretty thoughtful. What would you think, Baroness? Partner? What do you think?
I have to agree with Tori on that point. I think the first time around he had scattered ideas a little bit, but I feel like this time he really was absorbing your questions and kind of answering them to the best that he could. It was interesting to hear what his positions were on the two cases, as you guys discussed. But also, when he was on the podcast the first time, he discussed about how he wanted to bring the ATDS cases, and now that his position has changed, now that he's actually brought them and maybe not worked in his favor, he kind of is retracting from that a little bit.
Well, look, when your name is on a Circuit Court of Appeal decision destroying ATDS cases,
Maybe you're going to take a second.
maybe you don't want to bring those anymore.
Right.
But no, I'm glad you detected that as well. That's like he absolutely the first time around said, I'm willing to bring these cases, and this time at the end he was like, no, I don't like these cases anymore. I don't want to do this anymore. But no, I think he was very frank. I think he was very candid. I think he did a nice job kind of responding to questions. I agree with that. You notice he sued two Democrats? He sued Bradford, the Democrat, and the Democratic Committee. I didn't ask, it was a question that didn't get asked, whether or not that was a political decision. Is he suing Republicans or just Democrats? Maybe there's a little bit of like politicization to this.
Maybe, yeah.
So I don't know. Anything else?
I also did take note that when he brought up the Do Not Disturb Act, about how he wanted to pass and how he's excited about the ATDS definition. When we read it, we had the totally different opinion and don't want it to pass just because it's so broadly written.
Well, it makes plaintiff's lawyers rich.
Yeah.
So obviously he's going to want that to pass. I mean, if I was a plaintiff's lawyer, I would want it to pass, I guess. Although, look, I'm a defense lawyer. Theoretically, it would make me rich too. But I don't know. I'm just a purist, man. I don't want to see bad laws get passed. I don't care if it benefits me. I just think it's disgusting. All right. Anything else? Fantastic job.
Thank you.
Love it. Beautiful. Great. Hi, partner. Other partner.
Hi.
I have two partners now.
I completely agree that he was great or good or any of those positive terms as an attorney.
You completely agree or disagree?
Disagree.
Because you forgot the dis. The dis was not included.
Yeah, that's why I was like,
you said you completely
He
agree.
literally said, I'm not a great attorney, but, and I laughed because I was like, you're not yet a great attorney, Perrong, especially considering and comparing him to other plaintiffs' attorneys that we do go against. I mean, he completely bombed the first question of whether the governments are immune to the TCPA or not. He was flubbing all over the place. He didn't have any real argument. I think he got lucky in this decision, and I think that the defense attorneys, now I'm going to go back and actually read the briefing before I, talk poorly upon the defense attorneys here to really understand what happened here. But I mean, I just think he got lucky. I don't know that his briefing was great or that he was doing any type of great lawyering winning that case, but we'll see. The thing that I found the most interesting, though, is your question of whether subjective intent is going to be applicable to when you're evaluating sovereign immunity.
I asked interesting questions.
Yeah, that was something I didn't take into account, so I thought that was more interesting. And he didn't raise a brow or any of his brows when it came to when you asked him that question.
That was good.
I got nothing to say in response to that. Beautiful take, Queenie. Anything else?
No, I think he is growing up. I don't disagree with the girls in that he's growing up a little bit slowly, but I think he's far from being yet a great plaintiff's attorney. But he'll get there. He's just a baby right now. So
Well, yeah, that's what I'm saying. I like a guy that calls his shots.
Yes.
Right.
Yes.
When I was a young guy, I walked in and I wanted to be the greatest lawyer on earth. That was my plan. The first time I ever walked into a courtroom, I wiped the floor with the 30-year veterans, and I've been doing that my entire career. And now I'm the veteran, right? Which is weird because I'm so used to being the young whiz kid, right? The young kid that couldn't be beat. And as I mature and as the years go by, having that confidence, that ridiculous, who does this guy think he is, which I've always had, and I still do, but I've always had. I mean, I'm 25 years old and they're trying jury trials like I'm Matlock or something, right? Yeah. And having the belief that you are the next Clarence Darrow or the greatest or far greater than Darrow, right? The greatest has ever been from the moment you step into the courtroom for the first time. That actually leads ultimately to a career path, to choices, to taking opportunities, to taking risks that regular lawyers won't take. Something like working at this law firm, just as an example. So many lawyers are afraid, frankly, to work at a firm like Troutman Amin, where the standards are so high, where the talent is so elite, where the cases are so big, where the stakes are so high. Why would you want to live like this when you could go and just push paper in some small little office somewhere and get a big check at Big Law and never have your name in print and never have any, it's the old, man in the arena, right? Do you want to be the one with the lights on you, or do you not? Right. And so I respect that Perrong wants the lights on him. Yeah. He wants that.
And he's he comes off humble. Like when we were talking about his loss, it was interesting because he's like, that is now the case.
He didn't want to talk about it though. He did not want to talk about it.
But he came on the podcast. He knew he was going to have to talk about it and face it, and he looked us straight in the face and said, that is now the law, unfortunately. Yeah. So I respect that.
Well, look, at the end of the day, I think Perrong was very brave to come on the podcast, talk about pending cases. I think that's great. I got to give him credit for that. And again, I do think the fact that he wants to be a great lawyer, he wants to follow in our footsteps, maybe on the opposite side. I respect that, right? Like when I was coming up, I never had anyone I looked up to. Really, I've never looked up to anyone, and that's. I don't know what to say about that. I mean, you take from that what you will, right? No mentors, nobody ever said, I want to be like that guy one day. I was always just like, I'm the greatest there's ever been, and everyone's going to want to be like me one day. That's it. That's always been my mindset. He's looked at us, he's kind of locked on and said, these are a group of people I can learn from. I respect that, right? I mean, I let all comers, the old line of, just touch my robe and you'll be healed. Come, I will share. I will give you powers. I will give you wisdom. I will give you glory. And even if you're on the other side, if you want to learn from me and take something from me, I'm fine with that. I have no problem with that. In fact, more power to you. But for now, folks, that's all we've got for this. Our 25th episode of the Deserve to Win podcast. As always, I was your host, Eric Troutman, and we'll see you next time. Thanks, guys. Bye.